Today, we're talking AI and copyright issues with lawyer Brooks Marsh. This is an in-house counsel who has guided multiple tech companies through IPOs, mergers, and complex legal landscapes like the one we're discussing today. So with her tech startup background, expertise in digital media, privacy, and IP law, intellectual property law, and because she's great at explaining these things for people like me to understand, Brooke is our perfect guest for episode 20. So, without further ado, Brooke, thank you for joining. I'm super happy to have you.
Oh, thank you for having me. It is a true pleasure to be here today.
Thank you. So, Brooke, let's start with the basics. What is exactly copyright and why is it crucial in the context of AI generated content?
Um, sure. Let me just start with I'm not giving legal advice here today, but happy to explain the basics. So copyright, and I'm focusing only on the U.S., but
Hmm.
copyright law protects original works, such as computer code, audio or video recordings, photographs, artwork, books, blogs, etc.
Hmm.
And it is a framework of a federal framework meant to give creatives the ownership over their own works and a framework for protecting those works and the rights that come with them and the rights that don't.
Hmm.
And the copyright is created immediately. So whenever the artwork or the work is created, the copyright protection applies instantaneously. But the two caveats is that the work must be original, so it can't be a copy of something else, and it must be authored by a human,
Hmm.
which of course gets us into AI. AI land pretty quickly, but there have been prior cases with non-human authors attempting to get a copyright, which even well before AI, authorship had to be in by humans.
And I remember someone was bringing up on a previous episode this case of the monkey that took a picture. And I think it was either the owner of the phone, or I don't really remember. But the monkey took the picture. He wanted to register, and they said no.
Yes, PETA actually sued on behalf of the monkey for the monkey to have the rights in his selfie or her selfie. But the photographer had set up all the conditions, and so the photographer tried to get the copyright in it as well, saying, "Look, just for pushing the button,
Hmm.
everything else was me." And the copyright office said, "Nope, not a human, can't have it."
Okay, but Perk, let me ask you a question. And this is coming, I'm not a native speaker. I feel confident speaking, but sometimes, you can tell this is not my first language, right? So I use tools like Grammarly many times to help me, fine tune my writing, make sure I'm coming across as professional and eloquent. How would someone like me, for example, would that affect, let's say, if I write a blog or my memoir? Could Grammarly affect how much I can register for that, or how does it work?
So I'm not terribly familiar with Grammarly, but if Grammarly is merely looking at, if Grammarly is acting as an editor to correct the
Hmm.
grammar, then no, there's no issue there. You can still own your work. There would be no copyright issue. Where it comes into play is if you used AI or if you use any tool to translate into another language, the translation there's some art to it, right? To choose the right word, there is
Hmm.
an art to translation. Different words could be chosen. And so if you strictly use a tool like AI, since we're talking about that, or Google Translate, if you just use a translation tool, you cannot get a copyright protection of that translated work. The underlying work, presumably yes, but the translated work, no, because it's the machine that is making the decisions that otherwise a human being would have been expected to make.
Wow, you're already like throwing bombs in here because that's no, but I'm glad because I'm already learning. But that's so basically, if I'm hearing you correctly, let's say, right, let's get back to that blog post. Let's say they want to publish it in Latin America, right? So they translate to Spanish. If someone decided to just use that for something else, and this blog was translated using an AI tool, let's say Claude, ChatGPT, then I wouldn't have a claim in there. I wouldn't be able. Let's pretend we're talking about U.S. law, right?
Yeah, so that's part of why I said presumably you'd still have a copyright in the underlying work because it really depended on how the underlying work was created. But if you have a copyright in that underlying work, a translation is considered a derivative work of that original. And so if the translated text is taken, there may be still some copyright claims because of the original work, right? So somebody can't just take the Spanish version of your book, and just because it was created with AI, can't just go ahead and make multiple copies because if you still owned the underlying work, the original language, you would still argue some copyright. You would still have copyright infringement arguments.
Got it. But is there a way to determine this threshold? That's the other question, right? Let's say, again, back to my work. I wrote all the chapters myself, but the last one, I ran out of ideas. So I ran it through ChatGPT and just let it do its thing. How do we measure what can I copyright versus what I not? How is it audited?
Yeah. Well, we'll get to the audited in a second. But the test, there's no test per se. But if the AI is used as an assistance tool, so to correct a word or two, like we were talking with Grammarly, or I need help with this sentence, I don't love the construction, I'm going to put it in and say to ChatGPT, can you shorten it for me or change it from a passive verb to an active verb, something like that. And then you took that word and you continued to work on it yourself. Then I think there is an argument that you would still own it. But if you said to ChatGPT, here's the outline for my chapter, please write it, that is not enough for you to own what gets spit out for that chapter. So if you were to then register your book, you would say to the Copyright Office, say there's 10 chapters, I wrote 1 through 9, the AI wrote chapter 10. So you would get protection on 1 through 9, but not on 10. You don't have to register, by the way, but you still, regardless of whether you registered or not, you would own the copyright in that first 9 chapters, but not the one that was written by AI. And there's no percentage, right? So there's no kind of bright line rule. There's no test exactly, but there's guidelines. And if the AI is being used in an assistive way, so let's take video, for example, and you use the AI to blur faces or blur logos that you didn't get the rights to, that's okay. That's your video is still copyrightable. But if you used the AI in that video to create the background, to create some visual effects, that background, those visual effects would not be copyrightable. And so you'd be in a situation where some of the video would be and some of the video wouldn't be protected by copyright.
And I guess I'm glad you have this experience with complex legal situations, because as I'm hearing you say, right, like, for example, if you use your background, my brain goes directly to what I've been seeing here. I'm based in Los Angeles, right? And there's been a lot of talk, for example, about how you can create, there's no more need for location and scouting or like getting permits in other countries, because again, the technology at this point, or in a couple of months, will already allow us to get that beautiful drone shot using topographic data to replicate things better than the real thing, right? So if I'm hearing you correctly, as of today, September 2024, if I was Netflix and created a movie with that on my background, I don't know, was some space thing, that it's created with AI, that part of the movie would not be something where you can implement a copyright or own as your own creation.
Yeah, if the AI created the background fully, then that's correct, right? If you had, so Tiffany, for example, has that Tiffany blue. So if you were Tiffany, you created the background using AI, but the Tiffany blue was in there, that is still, the Tiffany blue is still protected because the AI didn't use that. So it really depends on the elements and what you've used. But for simplicity's sake, if you said to the AI, please create Mars for me, with,
Mhm.
a setting sun in the background, and it did, then yes, that background would not be
Mhm.
copyrightable.
You're giving me the perfect segue now that we're talking about training data because you just mentioned, right, this Tiffany blue, I think was the color. So if I was training, let's say that AI was entirely trained on all the pictures I took on locations that I had the copyright for, would that then be my creation, even if I'm training on my data? No.
No, because the machine is still determining how to combine the what it's trained on and spit out. So the output is it's determining the output.
Okay. I was the photographer setting up the camera, but then the AI was the monkey. So no stake for
Yeah,
me. Good to
yeah, yeah.
remember. But now,
Yeah.
Brooke, one of the main arguments that AI companies are using is that basically using copyright material for training, it's fair use because it's transformative, minimal, and paid for it would make their business unsustainable, stifling innovation, as they love to say. Now, me, as someone who gets paid to create content, not a lawyer, not a tech pro, my first thought, thinking in layman terms, is like, wait, wouldn't that be, maybe you heard this analogy, but like, I put it sandwich shop, but I just go and steal my bread because I'm like, bread's gotten expensive, inflation, and otherwise I wouldn't have a sustainable business if I have to pay. Like, what's the difference beyond me not being able to afford the lawyers they can afford?
Yeah. So I I don't know that fair use is a slam dunk argument by any AI company.
Mhm.
I think there's potential there. So let's first talk about the test. So AI was written into the copyright law by Congress so that somebody can still use a copyrighted work but can continue to innovate and create on top of it. And so the courts created a 4-part test as to whether or not fair use can be relied on rather than a license to the underlying work. So you had mentioned purpose and character of use. So the test is purpose and character of use, the creativity of the copyrighted work, the amount of the copyrighted work used, and the effect on the market for that underlying copyrighted work. And so I used to work with a bunch of marketers, and I would have to break the news to them saying, you as marketers can't really use this test. You're not creating and innovating, you're trying to sell products. And so the question really is, should you be paying for the underlying work? But when you're talking about AI, right, you are the purpose and character of the use. Yes, is it transformative? Is it creating something new? So when you're looking at it from the perspective of training on LLM data, so input, yes, I am creating something brand spanking new, you're saying, if you're the AI company.
Mhm.
So potentially, and we can get into the output, but if you're looking strictly at input
Mhm.
to train on, the purpose and character of the use is very different, right? So instead of reading a New York Times article, you're ingesting it to train. That is markedly different than what the New York Times was expecting.
Mhm.
Creativity of the copyrighted work can run the gamut. So whether it is an AP article, and I'm not trying to malign the AP, but typically that's just the facts, ma'am, right? So very very straightforward versus at times has its own voice, or go
Mhm.
all the way to album cover art or music, like very very creative. So the AI does not look at the creativity; it doesn't care. So that test may or may not be helpful. The amount used, all of it, right? So clearly that's not helpful for the AI companies. And then the effect on the market. And that goes back to input versus output. So you
Mhm.
have, I mentioned the New York Times earlier, you have the New York Times suing. And what they're saying is when you look at the output and you use prompts to say to these AI, can you please recreate the first paragraph, then recreate the next 5 paragraphs? If you do a side-by-side comparison of the New York Times articles, they're largely the same. Not a good fact for the AI companies. So you're really harming the New York Times' market to sell their stuff. But when you look at the RIAA, for example, their argument of there's no fair use here, they're harming our market. They're looking at the output and saying, hey, the music that gets created is harming our ability to sell our library. I personally don't buy that argument. I am not going to, not buy a Buddy Holly song because some new record music creator has used AI to generate something new and different. Like I find that a harder argument. What they're really saying is you're harming our ability to create licensed music to then sell. So I think that, anyway, I'm getting ahead of myself, but that's the 4-part test. Yeah. So I think when you're looking to train, I think, or if you don't, and we have a ton of license deals out there, right? OpenAI, the guys with a lot of the money, they have done a ton of deals. The smaller guys who are trying to create their businesses are relying on fair use, whether or not they think it's a home run argument, because they don't really have the money or the time to go out and do these deals. These deals are expensive. They're often a first impression, meaning it's not a cookie cutter deal that you then go and repeat, rinse and repeat, rinse and repeat. And, lawyers are expensive. So you'd have to hire lawyers to do all of this. So, and these folks want to spend their money on developers and, creating the best product. So I think then they're relying not just on fair use, but on the U.S. in trying to foster innovation, right? We have a history in this country of trying to be on the forefront of innovation. The internet is a perfect example where we didn't collect taxes for sales on the internet for the longest time. You hear conversations around 230 to give online platforms protections. That 230 was about UGC. You remember UGC, user-generated content?
Yes,
well, in the
do.
beginning, there was, yes. So UGC was a concern, so the Congress passed 230 to allow for this innovation. So I really don't see the courts coming down on the side of squashing this innovation. That being said, yes, you've got the RIAA that, frankly, they've messed up innovation in the past, but you've got these giant companies that may be able to go head to head, but you also have thousands, hundreds of thousands of small content creator, website owners, small business owners whose content is being taken by the likes of these giant companies. There you go. And you do a Google search these days, you see the AI summary. So now you get that answer and you don't have to click through to the website. So they're losing out on their advertising. So I do think that the fair use test is, I actually hope that courts don't get to decide. I hope that Congress acts before the courts decide, because if the courts start deciding, Lord knows what you're going to get, but you'll also get a patchwork, right? There's 9 circuit courts that could decide it 9 different ways. And now you have 9 tests. It's got to run through. You still don't have any decisions. It would have to go all the way through the appellate system up to the Supreme Court to make a choice. Nobody trusts the Supreme Court right now. So it would be best for, God help us all, Congress to act, which could also take a long time. But there is real benefit to acting. And what some of the smaller companies that I've seen do is start to aggregate their buying power or aggregate their voices and go to Congress together, and try to get the message heard that, we small businesses might have to close up shop, lay off people. You've got small businesses account for almost half of the workforce. And so if there's going to be an issue with the small businesses starting to get crushed, you're going to have some real downsides.
Now, my question would be, if I may ask it, which is like, how do you, from your personal perspective, see this playing out?
Yeah, that's a really good question. So the Copyright Office, all of the agencies are looking at this, but the Copyright Office did a notice of inquiry back last year looking at a bunch of different things. There were one of which was who should be liable for infringement if the output is infringing. So that's one thing we haven't really talked about yet. But The other is what type of a monetary scheme would you like to see? Um, and I think everyone would be willing to pay the copyright owners something, but I don't know that it's going to be enough. And I'll actually parallel this to something else, which is the cable television industry. So I know many young kids today, you young whippersnappers today, don't have cable from your traditional cable. You all cut the cord. But I worked in the cable industry, and one of my clients was trying to get carriage on one of these big cable companies. And if they didn't get enough carriage, which would pay them, say, 10 cents a subscriber, so they needed millions of subscribers this way, they couldn't pay for the programming, right? And if they couldn't pay for the programming, then they couldn't sustain their network and everybody would lose their jobs. And now that folks have cut the cord, the likes of, and now that the US Open is happening right now, the Tennis Channel has a problem, right? If the Tennis Channel only can have, say, let's say they need 20 million subscribers at 10 cents per, but let's say they have 5 million subscribers and they have to charge more, but people aren't willing to pay that. So it's a slow death. And I think we're looking at the same thing with the internet, right? If you're looking at these content providers, these website owners that make, say, $200,000 a year in advertising, but thanks to the Googles of the world, that's going to be cut down to 10% of that, or even half of that. Now, how many go out of business, and what do they do next, right? Do they go work for these large conglomerates? Nobody wants to do that. Not if you're an entrepreneur. So I think it's going to be trying to find the right balance is going to be tough. But I know that there's already been some calls to break up Google. They're just too big. And I think Google acting the way Google is acting, not a good idea. We have a fairly ineffective Congress, so I don't know how well this will go. But I think taking all of this content and making it, particularly at the search engine, so that folks don't have to click through, it's going to be a real problem. One of the other things we haven't talked about is I think that one way that this may get impacted too is power, and trying to find the energy for all of this AI uses. Everyone's building them, large companies, small companies, and all that computing power is expensive, and who's going to pay for that? So I think that's another cost that we've got to try to figure out. And just like the internet not wanting to charge sales tax on sales, it helped build Amazon. I don't know that you can give a free ride, but I don't know how you don't give a free ride. So I really don't. To answer your question, I have no idea. I wish my crystal ball was not so cloudy.
Yeah, honestly, I mean, definitely Congress has no idea. If we go, I'm sure you've seen that video in which Mark Zuckerberg goes to Congress and they ask him, like, how is Facebook making money? He's like, I mean, I never thought I'd be siding with Mark Zuckerberg in my life, unless you want to hire me, Mark, talk to me. But no, like, again, they seem very clueless. So that's not giving me a lot of faith. I do think if, kind of like, going back to what you were saying, one of the common themes that when I talk to CEOs that come into the show or other folks that are maybe have more visibility of understanding of the money aspect, VC and all of that maybe a creative doesn't understand nor care, right? And one of the things I say is like, there will be probably a situation like the dot-com bubble, right? We had the first wave in which you could get internet for free. At least I remember that in Argentina, every portal would give you free internet. You just have to have ads, and then like they all disappeared, because eventually you had to make money, right? Once the VC money runs out, there's a need for a business case. So I do think that eventually this first line of companies may well disappear and eventually will be down to Meta and Amazon. But now I lost my train of thought. But yeah, I just think it's kind of like going to be a bit chaotic, and then probably gonna get some sort of adjustment, but yeah, the creatives are probably gonna be on the on the lower end of the stick.
Yeah, yeah. And the creatives have found a way though. I mean, if you go back to the cutting the cord, yes, you don't have networks proliferating like you did, but you do have YouTube channels that are good for the the individual creator or a smaller team of creators. And so, maybe that's the way it happens, that creators are nimble and quick and can figure it out. I do think the folks who are being gobbled up, their revenue is being gobbled up by the likes of Google, that I do think I want to see Congress step in, or the DOJ, step in and have an antitrust suit against them.
Yeah, because I think it's a bit dangerous, right? When we start losing those kind of like mom and pop shops of information, then you start getting conglomerates that are going to follow an agenda, that have,
Right.
I don't know, investors that want to see a return of the investment. So you obviously do not want to alienate the people bringing in the money, the companies, etc. So
Yeah,
I don't know
it
what
is
that
tough.
would.
It is tough. And I do think you'll see a split. I think you've got the folks who will be really good at using AI to create new things. And I think music is a great example of that. I think music can use it, create really innovative stuff. Where you have the New York Timeses of the world, or all of those websites that do uh recipes, right? Where AI is just gobbling that up and regurgitating it. They're not creating anything new. Or the balance between a search engine and the folks who are feeding into that search engine to use, to get traffic to their sites. When Google regurgitates the information from those, I do think there's a difference there. And I think each will need to be treated differently. I don't think you're ever going to have a one size fits all, whether it's a fair use. I mean, that test is always so, fact specific anyway, but I do think you'll see branches of different industries using AI have different solutions. I don't think you'll have one payment system, because and maybe you go back to how creative, right? That test, one of the questions in that 4-part test is how creative is the underlying work. Maybe the more creative, the more money. But and just talking about the recipe sites, it'll take people dozens of hours to create a single recipe, and that's gone in a nanosecond when Google takes it and spits it out, or AI takes it and spits it out.
Yeah, there's definitely going to be a readjustment there. Now, Brooke, I want to look into the future. We've been doing some futurology here, but
Sure.
just today I actually decided I'm going to read a bill and see if I can understand something, right? So I grabbed the California Assembly Bill 3211, and basically I'm not I mean, again, I think it came out like a couple of days ago. I don't. Are you familiar with it?
I haven't read it yet, no.
Yeah. I haven't finished it, but I do have a high level that I'll explain for everyone, which is like basically it's requiring AI providers to add watermarks to AI generated content started 2025, and online platforms must label such content to reduce misinformation, right?
Yep.
Same for camera manufacturers, and there's penalties. There's actually penalties. A million kind of like chump change, but they're talking about 5% of global earnings. So that's like, okay, now we're talking that. Now that pay attention. So again, California always seems to be, and here's when I get the hate mail, but always seems to be ahead in progressive legislation, for better or worse. So how do you see this panning out in the future, right? Because we see California is taking a stand. I know there was another state. I think it was in Utah. No, Utah. I don't know if that is.
I mean, Colorado has done some. Colorado's been involved. So right now, a lot of the legislation and even the executive orders and the focus has been on the folks creating AI, so that if the AI tool gets in the wrong hands, you don't have very bad things happening. But and look, California tried this on privacy. Privacy is better done at the federal level so that there's not 50 plus privacy regimes in one country. But again, Congress failed to act. But I think similar to what I was saying with the courts, I think having piecemeal copyright protections is really hard. Because what do you do, right? It's not like you're only going to be using your work in California, right? It's so, and California has tried to be extra jurisdictional, meaning reaching outside of its borders, but they don't really. That now you're definitely stepping on the toes of the federal. So it'll be interesting, and I think I hope again that we don't live with a patchwork for too long. It's going to be too hard. I mean, it's hard already. We've been on, we've been chatting for not that long, and it's already so much craziness. And if we go through this for years and years, it's just going to be a mess. So
what a time to be alive, Brooke. So how are IP lawyers feeling about this? Because I remember back when it came out, I remember writing a blog that was like, IP lawyers are salivating right now, like, come to Papa, So what's the feeling? I'm sure you talk about to colleagues about this beyond marketers and creatives. Like, I know you do an excellent job educating us all, but how about like other lawyers that you talk to? How are they feeling about this?
In-house lawyers are feeling very stressed because it's just one more thing that they need to stay on top of. And there aren't enough AI experts out there to add one to the team, right? Similar to privacy. I had to cut my teeth on privacy because nobody else on the legal team wanted to. So I was like, fine, I'll take it. So I think AI is very similar, and it is so complex. And again, so many moving pieces that it's really hard. For the folks external, I haven't talked to anyone specifically about this, but I will tell you what a privacy lawyer said to me when privacy started to get crazy,
which is, don't worry.
Yeah. Which is, I have more work than I could ever possibly handle, which means I get to fire the clients I can't stand. So I think IP lawyers probably may end up thinking the same thing. Like, I could work 24/7 right now, and if you're a pain in the net client, then I don't have to put up with you. I haven't talked to anyone specifically about that, but I can see that happening.
Yeah, I could see that happening to creatives, if it was like 2019, 2020, when people were literally knocking on your door to see if you wanted work because there was such a need for content, which is not the case anymore. They don't want to pay anymore. But I do have one final question. We cover so much ground here, and I'm super once again. You're such a clear person explaining these very complicated topics. I'm sure, folks, I'm going to put chapters here so folks can re-go through. I'm going to rewatch this. I'm pretty sure I'm going to understand like way more after the fifth time. But let's say, one of the reasons I started this podcast is because I want creatives to have agency, not to cover their head in the sand, but actually, you know what? I'm going to know this better than anyone else because I want agency. I want to sit at the table, and I want to bring as many creatives as I can to that table, right? So from a lawyer's perspective, and keeping in mind, this is not legal advice. Nothing in this episode is legal advice. Go away if you want legal advice, or pay her. But anyway, what can we recommend? Is there books, YouTube channels, anything where you can be like, this is IP for dummies? At least it'll give you an idea of how screwed you are coming 2024, 2025.
One of the tools that I will sometimes go to, and they do talk, that one of their taglines is like legal information for the business-minded. It's called Lexology. Lexology, and they aggregate content from law firms that will do legal blog posts, and you can ask what you want to read up on. So AI could be one of them. The Copyright Office, their website has a good bit of information that, I mean, it's hard for me to know because I know it, but it seems easily digestible and easy to understand. You would be a better judge of that than I would, since I live and breathe it more, and I've taken copyright classes, ages ago. But other than that, I would just keep an eye on the news, and I would also kind of look around for not necessarily to learn about copyright, or maybe to get, you had mentioned the word agency, right? To pick up on some agency and maybe have a hand in your future. There are guilds, if you do a search for copyright and AI protection or things like that, you'll see some of the organizations that are trying to do something.
Mhm.
This isn't a nonprofit or a guild or anything, but Raptive is a company that helps a lot of blog posters, website operate small businesses. They have several thousand small businesses that they support. And they actually did a presentation in front of a bunch of congressional staffers recently. They've done a paper. And so I think, talk to your congressperson, talk to Raptive, see how you can get involved and pay attention. And this can be harder for some creatives, of the numbers. Are your numbers going down? Are you being hurt? Can you tie that? What are the numbers year over year? Facts. Do you have facts that you can share on how you're being harmed? And trying to get out there and getting the people that do have power to try to do something about it.
Those are some
that would be the
excellent
best.
suggestions, Rup. To be honest, there's so much homework because, again, remember when we first started talking, you even had to clarify to me the difference between IP and trademark. So the bar is low. Don't worry, I think you've given us enough. I'll be adding all these links on the show notes so folks can start learning because, again, right, we can complain, but if we don't educate ourselves, we don't take action. If we stay at home, just like going on Twitter or complaining about that doesn't change anything. So we got to get moving, write letters. I actually got a letter from Biden the other day. I'd sent a letter regarding some thoughts I had about things, and they answered. So I was like, okay, that's pretty cool.
There you go.
I don't think they're going to pay attention, but at least I got an answer. So that was pretty cool. But Brooke, today we covered copyright basics and AI context. Then we cover fair use, some licensing, data scraping, and finally what's next on future legal developments, how creatives can educate yourself. But now it's time for folks to learn about you. Where can they learn more about the work you do? I know you work mostly with tech startups, right? Is that the client that you usually work with?
My clients do tend to be tech startups, but I have some others, but largely in the technology space, AI as well. But you can always find me at brass.law or on LinkedIn, Brooke Smarsh.
Thank you so much, Brooke. I appreciate you joining the show. And so I appreciate you, dear viewer, as well, popping in for another episode. We're on episode 20, so I'm super happy that I still get to do this. And, without people watching would kind of suck, so I will still do it. But I like the fact that some people watch it. So, Brooke, thank you so much. We'll be including all your links on the show notes so folks can learn more about you. And this is
Great.
it. We're done.
Well,
Thank you so much, everyone.
Much.
Yeah,
Appreciate
have a
it.
good one.
Amo la creación en mi pantalla, bits y bytes en danza, todo brilla, cada código que escribo canta. Sabor a cumbia.